For people who've already joined us, we'll start in just a moment. We're waiting for people to enter the room. For people entering now, we'll get started in just a moment. All right, let's go ahead and get started. So welcome everyone to our copyright related FAQs webinar. We're so excited to be doing this for you all. My name is Dina Lozofsky. I'm the Senior Director of Business Development at UCLA's Technology Development Group. We manage all of the intellectual property that's developed at UCLA with the mission of promoting UCLA's innovation and research. And the motivation for doing this webinar was really all around how much more important copyright seems to be becoming to our commercialization efforts. I should say licensing efforts, both commercial and non-commercial. And it's not just software anymore. And that's why we're bringing to you our two experts, Angie Kujak and Angus MacDonald, to talk about some of the frequently asked questions that come up around copyright. I'll turn the webinar over to them in just a moment, but I wanted to talk just a little bit about logistics. So first of all, if you have questions, please put them in the Q&A box. You'll see that at the bottom of the Zoom window. We'll try and start taking some of those questions sort of live as we're going through, but there should be time at the end of each section and hopefully at the end of the webinar to address them as well. We have the webinar scheduled for an hour. The formal program will end at that time, but our speakers have graciously agreed to stay on a little bit longer than that if you still have questions. So we'll stay here for longer than that. And then the last question that I'll answer now is, yes, we will send the slides out. We'll make them available to anyone who registered. So with that, I'll turn it over to Angie for introductions.
Hi, I'm Angie Kujak, Senior Director of Contracts within UCLA's Technology Development Group. And as Dina said, the majority of the copyright related issues tend to relate to software, but increasingly it's relating to other subject matter and data. Other questions have come up. And so again, we thought it would be a great time to coordinate with the Office of the General Counsel in Oakland, Angus, and I'll let Angus introduce himself. And so we tend to work together that issues come into the campus, to my office, and then I coordinate and bring in Angus to help answer those higher level UC policy issues. So Angus, I'll let you introduce yourself.
All right, good afternoon, everybody. It's truly a privilege to be here with all of you today. I just learned something new, that Angie's last name is a silent J. All of this time I've been saying Kujak, not Kuyak. So I just learned something new. And I'm embarrassed that I've been calling Angie with the hard J, not the silent J. Anyway, I'm Angus. I work at the University of California's Office of General Counsel up in Oakland at the Office of the President. I am, for good or for bad, the lead counsel for all copyright legal matters for the entire UC system. So I work with all 10 campuses, all the medical centers, the UC managed national labs, on kind of the full range of copyright matters. And that would include drafting guidance documents and drafting policies related to copyright and assisting on putting up content on UC's copyright education website, which I strongly recommend visiting if you have copyright questions. And just a broad range of advice and counseling, including on fair use, among other things. I handle other intellectual property matters for the university, but copyright is by far my favorite area. And I just want to say UCLA has got phenomenal copyright resources throughout the campus, at the library, namely Sharon Farb, at the campus counsel's office, Amy Blum and Ina Bryant. And then you know, in Dina and Angie's office, the technology group, you know, you guys have people like Dina and Angie and others who are really, really knowledgeable about copyright. So they are wonderful resources. I just want to extend my thanks to UCLA's Technology Development Group for hosting this copyright webinar. And I really encourage folks to use that Q&A function, because this is going to be, the more interactive and engaging this webinar is with all of you, I think the better it's going to be. And we'll definitely try to weave in responses as we see your questions. And okay, great.
Great. Sorry, yeah, it was freezing. So just what we're going to cover. And what I did is I just jotted down everything that I had been working on recently in copyright, and I started seeing like recurring themes. And it is interesting. Angus and I have a lot of crossover, but he does see quite a few unique things because, again, TDG tends to be more central, more focused on commercialization of these assets, where Angus is also looking at it from a academic perspective as well. So we'll be touching on some things that we both tend to work on, and then some things that, like fair use, Angus has a little bit more experience dealing with those issues. So here, this just outlines the 4 main categories, and we'll be stepping through each of these. And so I'll just go ahead and move to the first slide here. We thought we'd start out with just some basics on copyright, because it's a complex question. We get that, you know, a question comes in, do I own this software? Well, there are many layers to that. There's the copyright issue, and that's what we're in copyright rights. That's what we're going to focus on today. But just because something, you know, you end up owning as a researcher the copyright on a particular asset, that doesn't necessarily mean that the UC doesn't have some other claim of ownership, whether it's through patent law and the patent policy, or there is a draft policy on research results, and there are some guidances at the UC level, UCLA campus, that govern research results. And Angus, maybe you can speak to some of those common overlapping technologies, or how you see how they interact.
Oh yeah, I mean, there's a lot of interaction, you know, among these 3 areas: patent, copyright, and research results that may not be protected under either patent or copyright. You know, just software is a great example of where there is a lot of overlap and different policies, UC policies, and different federal laws at issue here. So software can be protected by patents if it fulfills the requirements of being a patentable invention, but also the underlying source code underlying the software itself can also be protected by copyright. You know, if it satisfies the minimal degree of creativity that's required under copyright law. And different policies, whether you're talking about the copyright ownership policy for the University of California or the patent policy for UC, could lead to different determinations as to who owns what. And what I mean by that is that, generally speaking, anything developed within the course and scope of your employment at the university, if it's patentable, it's going to be owned by the university. I shouldn't even say generally speaking. I think just that is basically the policy. Copyright is a little bit different, depending on the type of work and the type of role that you have at the university. You could own your copyright, and the university does not own the copyright. So back to the software example, you could have a patentable invention that's related to the software being owned by the university, but the underlying copyrighted work being owned potentially individually. There are a lot of other examples about this overlap, and we'll touch on one of them in a later slide, the overlap between data and copyright. It is possible to have copyright protection over data sets, but usually data is not protected by either copyright or patent. So those are just a couple of examples.
Great points. And so you touched on ownership, and it is such a crucial determination in our office, because often we are trying to out-license the asset, and the biggest question and biggest, the most important hurdle that we have to cross is, do we own it? And do we have assignment of it to a degree that gives sufficient confidence to the licensee that we hold full title to it? And, I just put down the Constitution. I just always think it's so cool that our Constitution actually refers to copyright and thought it was important enough at that time to actually mention it in the Constitution. And Angus, so can you explain, if a licensing officer or someone like me comes to you and says, I'm trying to license this, can you help me determine whether we own it, or do the students, or does the faculty member, like, who's the owner? What's your analysis sort of involved?
Yeah, that's a great question, Angie, and it's certainly a question that comes up with some regularity in my own practice. There's actually a lot to unpack here, but I would say the very first place that I go is actually straight to the University of California's copyright ownership policy. And it's the policy that's referenced on the slide. It's the 1992 policy, which, by the way, as you can see in the parenthetical, there is a substantially revised version of that policy that's going to come out any day now. I actually was hoping that it would come out right before this webinar, but I anticipate it will be issued by President Drake, UC President, President Drake, in the next couple days, hopefully by tomorrow. But I start with the policy because the policy itself outlines a number of different categories of copyrighted works. And for each category, there's a statement as to whether the university owns it or whether the underlying author or creator owns it in their individual capacity. And then when we look at that policy and we look at those categories, oftentimes, whether something is owned by the university on one hand versus the individual author on the other hand, is usually comes down to whether the author is a staff member of the University of California or is considered an academic appointee. If staff, then it's most likely going to be owned by the university if the copyrighted work was done within the course and scope of that employee's employment at the university. But if it's an academic appointee, like a faculty member, and has a research article, a scholarly article, that's most likely going to be owned by the individual. I also look at various other categories, like whether it's a sponsored work. If it's a sponsored work, it's likely going to be owned by the university. Whether there are any third-party rights that might be implicated, or even a contract with a third party as to ownership by either the third party or the university. And then some other questions that I look to and that are built into the UC policy, the 1992 policy, is whether they're joint ownership rights. And then there's special inquiries about software that I oftentimes do with people like Angie or Dina or others, which are, if it's a software work, is there any third-party code out there that could implicate ownership? Are there open source software built into the code that either the university or the individual is claiming ownership over? So those are just some of the things that we look to. And again, I would first look at the 1992 policy to kind of help sort out the ownership determinations.
Great. Yeah, I know Dina and I just, for example, this week dealt with something where, and you'll hear us say this over and over and again in this presentation, where contracts can be really helpful. One faculty member in France sent to our faculty member a protocol. Our faculty member translated that, modified it a little bit, and all of a sudden now we want to do something with that. Well, untangling that, figuring out who owns what can we do with that, what permissions were you expressly given by that French research team? Unwinding that is a lot more difficult than proactively addressing it. And sometimes, and that's what the goal, I guess, of this presentation is, to issue spot a little bit, help you realize, oh, maybe we should put a consent form at the beginning of this research project in place that states, and gets a signature from every student that's on the project saying, given that you have unique access to this work and it's funded by the federal government, you agree that we owe certain obligations to the federal government, and you will assign your interest to us so that we can grant those rights to the government as required under the grant. So that'll be a recurring theme. Just if you can paper it, that's the best. You know, even if something feels and looks and everyone knows it's work made for hire, you hired that consultant. Dina and I had another situation where we had code. A faculty member hired an external consultant to draft some code, and no contract was put in place. And unfortunately, these are lost opportunities. They probably knew they were a consultant and were supposed to assign to us. We were confident. It must have been the researcher was confident. Oh, they know I'm going to own it. But pointing to a contract is always the clearest way to address it.
Yeah, Angie, I just want to underscore that fact. So the Copyright Act of 1976 provides default principles under federal law as to who owns what, among other things. Our UC policies do modify the default principles under federal copyright law in minor ways. But all of that, both the law, federal law, and our policies can be modified in terms of the ownership determinations by contract. So it really does help to have the contracts, you know, clearly delineate ownership, so we don't have to necessarily resort to what the federal law says or what the policy says, especially if the intent was different than what the default principles provide.
And it may be that the policy does sufficiently cover us and say that we do own it, but then you have to make that argument, that extra step. And if you have a contract, it's just clear, you can place it, you know, in something tangible that everyone can look at. And so, yeah, we'll move on to that next. So you referenced this a little bit, or at least hinted at the revisions that you were hoping to get issued. Can you tell us a little bit, Angus, about the changes that are being made to the 1992 copyright policy? What are the high level?
Yeah. So the 1992 policy, that is the main policy. And there is, by the way, a separate policy for course materials, which is the 2003 policy, which is not being updated, at least not yet. But it's the 1992 policy that's been the policy system-wide for determining copyright ownership. And obviously it's been in existence for now 29 years, but it's starting to feel its age. And there are kind of repeated areas of friction that we have tried to address in this revised policy, which, like I said, is going to be issued any day now. And it actually represents a fairly significant achievement and balancing of a lot of different stakeholder interests within the entire university system. So this slide, I'm not going to read it, but the slide highlights the key substantive changes to our the revised policy compared to the 1992 policy. We see the eligibility requirements. There's a clarification and even an expansion as to which individuals may own their copyright to works that were created at the university. The second point about the pool of works being clarified and expanded. We made clear in that the pool of works to expressly include software, which since 1992 has been the source of some disagreement as to whether software is included within the scholarly and aesthetic works category. The third bullet point, significant university resources. The main point there is the 1992 policy only referred to university resources, the use of university resources as triggering the university's ownership in a work. And we built in a limitation to make clear that no, it has to be significant university resources. And we provide some clarification on graduate students and when they can own, because there's been a lot of issues arising there. There's actually many other changes to the policy. And I just want to, setting aside these major substantive changes, there were some other key items in the policy, the revised policy, that I want to highlight, because I think it's particularly timely since the policy will be issued, the revised policy will be issued any day now. It's much more simple, in my opinion. We've eliminated a lot of the legalese. We've eliminated a lot of other terms that just were inherently confusing. We purposely drafted the revised policy in a way that you do not need to have a law degree, you do not need to have substantial copyright background in order to understand the basics within the policy. We really strive to have as much clarity as possible on these various categories that I was describing earlier. And another goal is we really tried to bring the copyright policy into the 21st century, because the 1992 policy, think about it, it was pre-ubiquitous internet. And so, the idea of websites wasn't really fully developed or even partially developed in 1992. So, we have those types of media included within the revised policy.
Angus, as the non-lawyer on the panel, I just wanted to vouch for the fact that the language is much more plain language, and I appreciate that too.
Thank you so much, Dina. It's always a goal. It's my I get tired of the wherefores and the heretofores and all this other witnesseth. It gets really tedious, and I'm a strong subscriber to the plain English for lawyers model.
And just to add to his second bullet point on software, just from the technology development group's perspective in UCLA and software, just that is a perfect, again, example of where there's crossover. So although maybe the copyright policy, if you take a look at that, you didn't create it through contract and it's deemed as scholarly and aesthetic work, please come and ask us and we'll do that, help you make that determination and conclusion, because it's possible that there's other reasons why the university might own it. So software is just, again, one of those tricky subject matters that just, it's better to ask, and which leads greatly to the next slide, which is why. It seems like there's such a headache. I have to now call Dina, and I have to ask her, and then she's gonna look at it, and then everyone else is gonna look at it. I just want to go off and run and start, commercializing it. I'm pretty confident, maybe not perfectly confident, but why not? Why, Angus, why might you pause there? Why is determining ownership really important for faculty and anyone else this applies to students as well, who may have created software while they were on UCLA's campus using facilities or as an employee?
Well, there are many reasons. I'm not going to go through all of them, but the primary reason, at least for the purpose of this webinar, is if you don't have clear title, you're not going to be able to exploit the work, meaning commercialize it or license it. Many of our licensees require some sort of warranty or representation that we actually own the thing that we're about to license. And if we have some questions as to whether we truly own those rights, just as a practical matter, it makes it much more difficult to actually license or otherwise commercialize those rights. And these copyright ownership issues do come up frequently, and that's unfortunate. And it comes up, internal to the University of California, whether, on one hand, the university owns it versus the individual faculty member, for example, but it also comes up frequently in dealing with external parties. And that just, unfortunately, just bogs things down in terms of getting the copyrighted work. Oftentimes it's software or other copyrighted technologies out, either to for the public good, or to get it out to licensees and to kind of, realize a rate of return on the works that were developed at the university. And so, it's a lot better if the ownership principles and the ownership determinations are made clear at the earliest stage, so that to avoid disputes and to avoid gray areas coming up, and to provide those guardrails at the earliest stage. And the best way to provide guardrails is through contract, is to clearly delineate who owns what, at the earliest stage possible. This comes up a lot of times. I'm not going to go through all the examples, but you cite other reasons in the slide that's being presented. You could put in a lot in terms of the revenue share and who and other obligations and future R&D all in the contract. So I do recommend getting that clearly delineated early on.
Yeah, and we'll hint at this again when we talk about enforcement, but as Dina and I can attest that we see lost opportunity most of all. Maybe there's not a lot of copyright infringement actions happening. You hear about patent infringement, worried about patent infringement or wanting to sue about patent infringement. You don't hear that same noise about copyright. People aren't going to court as often suing over copyright infringement. However, that doesn't mean that there isn't great value or value lost. And so we see that, or a delay into the marketplace. So for us, it's a gating question for a lot of companies. We're not comfortable executing this agreement until you can give us all of these assurances. And so that just slows down the startup from raising investment, from getting ahead of potential competitors. So what rights do you have as a copyright owner? And I raise this because Dina and I work with patents so much. That's what we're thinking most of the time. The rights you get under patent laws. You have the right to exclude others from making, using, selling, offering for sale, and importing. And it's really an exclusionary right. An independent invention doesn't matter. Someone didn't need to know about my patents in order to infringe. I can stop them anyway, even though they independently in their little room all by themselves came up with the same thing. So can you talk a little bit about the rights under copyright laws and maybe how they differ a little bit?
Yeah, sure, Angie. So you've got the main rights up there presented on the slide. It's the right to reproduce, distribute, display, prepare derivative works, and to perform the work publicly. I just want to say that the derivative work right tends to be a bit more complicated than the other rights, the reproduction, distribution, and publicly perform and publicly display rights. And we're going to get into that into the next slide. So I'm not going to, get too much into the details, but generally speaking, under US copyright law, the definition of what constitutes a derivative work is actually quite broad, and it could lead to some ambiguity, especially if contracting parties decide to vary the definition of derivative works by contract. You had mentioned key differences between patent rights and copyright rights, and one of the key differences is, patent rights, and you referred to the right to use, make, use, offer to sell, all those great things. I sometimes see in copyright licenses, the license grant is drafted in the form of the right to use the copyrighted work. That's okay in the patent world, but it's really problematic in the copyright world because the rights are described in these 5 rights that are on the slide. And it's much better, and it really is the proper practice when granting a license for a copyrighted work or for the copyright itself to identify which of these rights are the ones that are truly being licensed and not phrasing it as the right to use. And the reason why that matters is you could grant, all of these rights are divisible by the copyright owner. So you could grant an exclusive license for the reproduction right to one exclusive licensee, but then grant separate rights, separate exclusive rights for the prepared derivative work right. And that happens oftentimes in the film industry, is that different parties have different exclusive rights. And just saying, well, you have the right to use, that's inherently ambiguous. So that's one key difference, is not using the right to use in copyright law, whereas it's perfectly appropriate in patent law. The other, I'd say, key difference is in copyright law, as long as you independently create something, even if it's identical or substantially similar to something that's already been created, that won't be copyright infringement because you didn't actually copy the prior work. You independently created it. That's not the case for patentable inventions. If a patent holder has valid rights, even if you independently created the technology that's embodied in the patent, that could still lead to a patent infringement charge. So those are the two main differences.
And I just wanted to point out,
okay.
sorry, Angie and Angus, we're about halfway through the time, just pointing that out.
Yeah, and so just, I think you referred to a lot of this, Angus. I can kind of gloss over this, but I think we are traditionally thinking from a layperson like, oh, book, I'm going to give play rights to this, to this entity. I'm going to give the movie rights over here. In fact, I'm even going to chop up sequels and different iterations of the Harry Potter movie to different directors or to different film. But in technology development in our group with Dina and I, it gets a little bit stickier when we're talking about software. I get that question a lot, like, how long until my work is no longer a derivative work of the prior person's software that I based my software on? And I'm not going to clearly go through these details. It's quickly, I ran through the test just for my own edification, like, gee, the circuit courts are, different court systems are all over the place on how to analyze whether one piece of software is a derivative work of another. The process in which they analyze that really is all over the map and not a well settled question. And it comes back to just contracts around that. So it was interesting. Angus and I were having a conversation the other day. I'm like, well, how do you define derivative work? And you said, just so bluntly, just refer to the statute. It's anything under the statute, and then let's handle it in a different way instead, as far as define how long their financial obligations last. Expressly state who owns those modification and derivatives, what they can do with them when they're free of obligations. So again, contracts become exceedingly important, and just be very plain and clear about all of these issues. Predict what issues could arise and preempt them with language that addresses and contemplates that, in the future, do all derivative works, are they owned by the original work owner, or are they going to be owned by the licensee? And what are the ramifications if the licensee owns them? Can the licensee go off and commercialize those derivative works without returning any kind of financial consideration back to the original work owner or the original software owner? Spell those things out in the contract.
Angie, can I just chime in real quick? And this will take 15 seconds. As a best practice, when the university owns the copyright and is licensing it to a licensee, and the licensee wants to own the derivative work right, I strongly recommend pushing back. I do not like, and just as a best practice, this divided ownership model, it gets confusing. It gets confusing to draw lines as to what is a derivative work. And so the best practice, as much as possible, is owning the original work and owning the derivative work. But if the licensee wants an exclusive license, then being flexible on that front, but trying to maintain ownership over the derivative work rights.
Yeah, that is the ideal. You've seen me squirm in my chair a little bit, because in the technology development group, like, we're trying to get those technologies out. And sometimes you're dealing with a company like GE, a Fortune 100 company. They're not going to give up ownership of the derivative works that they've plugged millions of dollars into. But there's contractual ways that you can get around that issue. Maybe it's not so important that UC own it, but maybe GE can't do anything with those derivative works absent having a license to the original work. And they can't use them after the license agreement terminates. Maybe they don't have to, maybe we don't have to own it, but after termination, they have to share copies of it with us, and we can redistribute it should they terminate their license agreement, so that our other future licensees can use and work off of that derivative works. So there's just ways that you can build contractual provisions to push for the outcomes that you want. But again, go to your technology development group on campus here to talk about how to do that. And this is the topic, so fair use. And Dina, did you have a question?
I did. Someone asked for a clarification in the Q&A box. By default, the licensor would own derivative works if silent on the issue?
The answer is yes. Because the derivative works right is one of the exclusive rights under Section 106 of the Copyright Act, those 5 rights that we were talking about a couple slides ago. In the absence of some statement as to who owns what about the derivative work, the licensor, the original copyright owner, owns the derivative works that are created by the licensee.
And if someone adds something to that, that protection is thin. They're only really that derivative work creator, the one who's adding, and I always bring it back to imagine the original work is an A and someone's adding B to it. By adding B to it, you don't all of a sudden get to run off with A plus B and commercialize, because you still have that original work there, A, that belongs to that original owner. That comes up quite a bit. So great question. Fair use. Now this, at first I thought this doesn't come up on our campus a lot, but then as I thought about it more, it does in different ways. But I know, Angus, you deal with it quite a bit. Can you just give a high level overview of what fair use means, kind of how you approach the question when it is posed to you?
Yeah, and I'm mindful of time. So the thing about fair use is that you can spend easily a 60-minute or 90-minute webinar just on fair use law under copyright. There's a lot there. I'll try to do it in about 30 seconds. Fair use is one of the greatest aspects of US copyright law, in my opinion. Many international jurisdictions do not have a fair use law that's codified within their overall copyright law. And the central idea of fair use is that there are certain uses of copyrighted works that are just going to be presumptively fair. It has a utilitarian benefit for society. And within the US, many of those uses flow directly from the First Amendment. Uses such as criticism, commentary, news reporting, those tend to be presumptively fair use. The university benefits tremendously from the fair use law under federal copyright law, insofar as when we're using copyrighted works for the purposes of scholarship, teaching, research, they are often considered fair use. It's not necessarily automatic by any stretch, that because you're doing something within the context of university teaching, research, or scholarship, that it makes it an automatic fair use determination or very, very likely fair use. You have to go through the fair use factors. Copyright law, these are the 4 fair use factors that are presented on slide. You go through each one of them, and then you have to balance them. I don't have enough time to kind of go through each one of them. And there are a lot of gray areas, admittedly, about fair use. But I would say that there are a lot of resources, both at the system-wide level, at the campus level, and just online. And Angie has, on the links over there, at the very, very bottom, so we have the UC Copyright Education website that has an entire section devoted to fair use. There are links to fair use checklists that are purposely written with the academic in mind, not a lawyer, not someone experienced in copyright law. And so I recommend taking advantage of these various fair use checklists, taking advantage of the UC Copyright Education website. Libraries, especially UCLA library, have there's superb guidance and superb resources on fair use at the library. So, and then of course we have the system-wide policy on fair use, this 2015 policy, which is linked in the slides there. The most relevant item in that policy is that basically, even if you make the wrong determination on fair use, that let's say it's just not fair use, but as long as it was a reasonable, good faith and informed analysis, even though it might not qualify as a legal analysis on fair use, the university will defend you to the greatest extent allowed under law for any sort of infringement claim that arises. So you always have that. We've got your back, basically.
Right, and as Angus said, there are a lot of hyperlinks that have embedded, and when we circulate this, I've tested them, and they will take you to the correct places. I have a lot of these bookmarked because nothing's easier than just directing the faculty member, explaining this is what I think the outcome is, the link. I do that many times a week, particularly this one chart on ownership. We covered ownership. There is such a great chart that breaks it up and easy to understand pictures for, because I have to go back and say like, okay, which bucket is it in? And I end up just referring to faculty because then they feel more confident too with the answer I've given. So moving on, you know, the hottest topic right now is course materials for me, and due to remote working and remote learning, more and more faculty members are making this course content and recording course content because of remote distant learning. And they're saying, what can I do with this? How can I control it? I'm worried students are going to share it and post it on websites that I don't want it to be on, or I want to preserve this because I might be making and building something cool here that I'll be able to sell. What can I do to protect it? And there's many layers to this. So we'll first start, and this is really part of the basics too, is marking. You know, under copyright law, what's cool is that you don't even have to mark in order to have copyright in your work. Just by reducing it to a tangible medium, you have copyright in that work, to the extent it meets certain thresholds of creativity and originality. But marking does provide some protection. And I think a lot of people are pretty familiar with the copyright symbol and see this copyright language frequently on the documents that they read. Angus, what are some of the advantages to marking? Like, why mark if you don't have to?
Yeah, great question. There is a public notice function about marking, saying that a particular work is copyrighted, and that public notice function extends to if you have beyond just the copyright sign and also the year. If you say who owns the copyright, so here in your notice, your copyright notice, you have UCLA. So, okay, that's good. So now we know that it's both copyrighted, we know when it was copyrighted, and we know who owns the copyright. And then if you provide additional information, because a lot of people, I believe, are honorable, lawful people, and they want to do the right thing. And so sometimes they want to use a copyrighted work, but they don't know how to get permissions. And having that additional statement, you know, for use permissions, contact that email address. Those are all extremely helpful. I think another advantage of marking is that it just deters infringement. I think there's this common misconception in copyright law that if there's no copyright notice or no copyright mark, then it is in the public domain. False. But still that view remains that if you don't have the notice, it's in the public domain. So if you want to avoid infringers, or at least you want to deter infringers, it helps to have a clear copyright notice. There are a lot of other benefits. I mentioned some of them, you know, about the clarity of ownership and giving the year, which helps determine, you know, how long or when the work goes into the public domain. So that's the main advantage of the copyright notice.
Yeah, and what I like about, you know, it deters infringement. I also find it's advantageous to the researcher because it might actually improve dissemination and use of the work. So many researchers publish because they want their research to be picked up and used and to become relevant to other researchers. And if you're very expressed about what they can do with that work, I spend time when we get questions trying to hunt down, like, who at Harvard am I going to contact to be able to see if she can use this picture that was taken in 1972. Make it easy. I'm sure that person back then would have wanted to, given the type of work it was, would have wanted people to use it, to disseminate it, to continue the knowledge of that work. But unfortunately, without clear directions, it was just another lost opportunity. So it can actually work the opposite too. It can quicken how your colleagues or your counterparts pick up your work and use it.
Yeah, that's right. That's right about attribution. I just want to say, like I said, most people want to do the right thing, but sometimes they don't know how to provide the right attribution to the original copyright owner, to the user. So having a good copyright notice helps to on the attribution front for research articles that cite to the original copyrighted work.
Yeah, and I threw this slide in here just as an example. Like, this is the one I send around when I get asked, hey, I have these materials, I want to quick make them available, but I don't want them used by anybody but this particular person that I'm sending it to. Well, this was what was on a teaching manual that I paid for. And they really hammered me over the head, like, this is for you, you only, you can't transfer it. We have this like scary tracking code. So there are many layers, all the way from what happens when, no marking at all, to marking, to maybe being very express what they can and cannot do. And even you can define the penalty. So there's a plethora of options. I explained to Angus, even on another website for teaching materials, I couldn't even download or copy and paste the reading materials that were in her website. I could only view it while logged in and opening the PDF, and the PDF was completely protected. I couldn't print it, I couldn't do anything with it. And it deterred infringement. It deterred me from downloading. I wasn't going to infringe, but I did want to have a copy so that I could highlight it, but it was untouchable. So it's interesting how this field is moving in a way to make really cheap ways to disseminate works, yet protect them. Because infringement, you're not going to bring an infringement action given the costs. And we'll just very briefly talk about this.
Angie, I'm so sorry to interrupt. There was a question that I think was on point to the previous slide, which is, and it came up a bit ago, about this, when there's a disclaimer or a statement that says, any uses of my copyrighted work are illegal without my permission. And the question is that sort of the copyright statement, is that kind of a hollow threat? Is that really true that we are violating copyright law if we, reproduce any portion, even a small portion consistent with fair use? And the answer is yes, it is hollow. This, in fact, Angie and I, when we were working on the slide deck, I looked at this all rights reserved language, and my initial observation is technically this whole sentence about no part of this publication may be reproduced, distributed, or transmitted in any form by any means, blah, 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 except in these very limited ways, brief quotations, or certain other non-commercial uses permitted by copyright law. I actually don't think that that is an actual statement under copyright law. It is true that generally you can't reproduce, distribute, and do all these other things without the copyright owner's permission, except if an exception or a defense applies, and fair use is one of them. And there are actually other uses that are permitted under the Copyright Act that we at the university can avail ourselves of. So some of these disclaimer languages or copyright statements are actually not true. And they do have, they are a hollow threat, but nevertheless, they are effective. And just to underscore the point, having these statements help in terms of deterring infringers. And oftentimes course materials are uploaded onto third-party websites like Course Hero, and having these statements help to filter out those copyrighted course materials from being uploaded in the first place onto these third-party websites.
Yeah, great point. And it is all about preventing the infringement, or if you really want to try to protect the value of the asset. I'm sure this was inserted to scare me, to not hit forward, the tracking code. I wasn't entirely sure. I'm like, are they tracking my computer? It might not even do anything technically. So I just thought it was interesting and something to share, like, hey, there are ways and cheap that you can do to try to limit, whether it's like a physical locking mechanism or even words. What would be really helpful more and more is, and if you want people to use it a certain way, expressly state that, you can copy this and distribute it, you can incorporate it into your work. If using it on the flip side, like, it would have been helpful for many issues that I deal with if they just would have said we can use it for certain circumstances. The language that sometimes they use isn't sufficiently clear. Like, does the phrase "you have the right to disseminate this work," does that mean I can incorporate it into my work and disseminate it? Or does that just mean I have to disseminate it as is? So use language that's clear, plain, and direct whenever possible. We've been hinting at enforcement. It doesn't often happen. I'm assuming it doesn't happen at UCLA a lot, Angus. I presume it's not happening a lot at your office of the president level as
Right.
well?
As a general matter, we don't file lawsuits for copyright infringement. We do some copyright enforcement through cease and desist letters or other more informal means. But as a general matter, I mean, I've been at the university for almost 8 years. Copyright comes within my purview. I cannot recall of any copyright infringement complaints that we have affirmatively filed against a copyright defendant. We've been sued a couple times for copyright infringement, but we haven't sued somebody else. Usually because we resolve matters through informal means, which is much better and much less expensive and much less of a headache than going through a lawsuit.
Great. I'm going to just jump to this next topic as quickly as possible because it is such a frequently asked question, and that's data and databases. I thought it was interesting the U.S. Patent and Trademark Office in late last year, November, December, put out a request for comments on data. Are we doing enough for data? Is copyright sufficient? Should we do something like the European Union? Should we provide some sort of database right? Tell us what you need. And what was interesting, what came out of all of that, and it seemed to be repeated by large companies and even universities, you're really going to have to rely on contract under the current state of things. That's not to say that you don't have copyright, but if you really want to be sure that you're protecting your rights to either data or some database that you've created, contracting is really where it's going to be. But that said, Angus, can you explain what kind of copyrights you might have around data and databases?
Well, it's going to be thin. If you can get copyright protection in the first place for data or data sets, it really will be thin because copyright law does not protect you can't enforce rights against facts. And a lot of data are just facts. What you can get protection for with respect to data sets is if the term of art is the selection, coordination, or arrangement. If you have arranged the data in a creative way or that constitutes creative expression, then you can get some protection over the selection, coordination, or arrangement of that data. Just to be clear, if you arrange the data in some sort of alphabetical or numerical order, that's not going to constitute creative expression that for which you can get copyright protection. And if you invested a gazillion hours of your life obtaining this data, but you didn't necessarily arrange it in any sort of creative way, they're just done in alphabetical order or numerical order or chronological order, that also is not sufficient for copyright protection. That's called the sweat of the brow theory. That was the Supreme Court looked at it about 30 years ago and just said, no, sweat of the brow is not a sufficient basis to get copyright protection. It has to be creative. So if you arrange the data in a creative way, you can get protection, but it's the best option is if you want to protect data, protect it by contract, not copyright law.
Yeah, and I get this question a lot about data, particularly medical images, and I imagine with so many large campuses with hefty health clinics and facilities, that you must see a lot of this as well, where how do you describe to someone, what do you have to do? You can't just, as you said, take a bunch of facts, put them in alphabetical order, take a chest x-ray from 100 people and say that there's something special there under copyright law that rises to the level of it being copyrighted. But if you do something more, and I think this slide just does a quick, nice job as to telling you just what we're stating as far as what's in the public domain or not copyrightable versus copyrightable versus a derivative work. I'll just move on because I do want to get to this last bit. Open sourcing. We get these questions a ton. And they tend to fall into two different subject matters. There's the software, and that has lots of resources everywhere, and we'll walk through those really quickly. But first, what about everything other than software? I'm seeing this more and more pop up where they're like, I want to quickly disseminate this work, but I only want academics to use it, and I don't want companies making money from it. What can I use? And I turn myself to the Creative Commons, this attribution non-commercial share like 4.0, And what I thought was awesome is that there's so many iterations of this you brought to my attention, that there's a derivative work too. So you have to think through and make sure and if you're on the resource side of things, if you're in like someone like the technology development group and you're answering these questions, to be sure to ask your customer, what is it that you want to enable? Do you want to just distribute it and they can't change anything and you want them to not be able to further distribute it? Or do you want to enable them to just change it up and make modifications and share it with others? Really nailing that down, because that's going to depend and dictate which license is most ideal. Now, when I first joined UC, I know, Angus, you were working on a big open source initiative, because it is a big field of questions, and it has definitely resolved a lot of the noise we've had on campus at UCLA to answer those questions, because I can point them to something that's very clear. Do you want to talk a little bit about that resource? And I'll flip to the next slide. This is where I took an excerpt to kind of help that explain what it is that you're going to talk about.
Angie, if you don't mind, can we just go back to the previous slide? I just want to say one quick thing about Creative Commons licenses that relate to open source software licenses. The biggest issue that I see about open sourcing, which, by the way, the university is all in favor, under appropriate guidelines to open source materials. Part of our mission as a university is the wide public dissemination of the knowledge that we develop here at the university. The biggest issue I see, however, is that folks just decide on their own to say, you know what, I'm just going to release this under a Creative Commons license. Or, you know what, I'm going to release this Regents owned software under an open source software license on their own. And technically, you have to go to the delegated authority for university owned content. You have to go to the delegated authority, and it's only the delegated authority on copyright that can make that decision to open source either software or to release content, non-software content under a Creative Commons license. So I just want to really underscore, and the right folks are probably Dina and Angie, or at least their office certainly has a delegation of authority with respect to copyrighted technology owned by the university. So I just want to make that point. Now, if we want to go to the next slide, Angie, sorry about that little brief aside. Yeah, so the university about 3 or 4 years ago, released some guidance on open source software, because we were getting a lot of questions all of the time, and we were doing all these clunky workarounds. And the reason for these workarounds has to do with the fact that some of the most popular open source software licenses, namely GPL3 and Apache 2, are patent granting licenses. And what that means is that if you have any, if the technology for which we are open sourcing is covered by a patent, then we are giving the world a patent license. And that could be problematic for a number of reasons, and we don't have time to get into it. So what we did is we created this guidance, and we created this chart that Angie has depicted on the screen right now. And this was actually a revision of an earlier chart that had a lot more red and a lot more yellow. Yellow and red, yellow signifying moderate risk and red signifying high risk. All of these resources are available on the UCOP. If you just type in on Google UCOP OSS or open source software guidance, the link that's on the left over there will come up right away. And if you scroll down to the bottom, there's all these other links. And this is the top link, which is this chart. And basically, the short of it is we've given the campuses more authority to enter into the Apache 2 and GPL licenses. And when I say we, I'm not talking about OP. I'm just saying that, collectively, the university stakeholders, mostly campuses, have decided to have more permissive entering into these open source software licenses without encumbering the university-owned patents. So lots of guidance there.
And just a quick plug for UCLA's resources. And this last slide has additional links. We're running short on time here, but I do want to put a plug in for all the work that Dina did when she first came and joined our office. She really did a terrific job honing in and bringing in all of these great resources into one easy place on our website. and it's in our FAQs. And in particular, on the open source questions, we've also come up with our own language. If you even want to further simplify and just exchange your code between two academics, with something that open source licenses don't allow. You know, when you send something out in open source, it's commercial use. There's no way to limit it like you can under Creative Commons, and you can't use Creative Commons for software, or they highly recommend against it. So we've come up with sort of our own flavor of that, Creative Commons, non-commercial, no derivative, or it does enable derivative version of that. So please visit our website if you have any questions. All of these are hyperlinks. So again, I've provided links so you can find these things more easily, including what I just referred to, those FAQs. I really want to thank everyone, and I'll hand it back to Dina here to close it out. But thank you for listening in on this very interesting conversation.
Thank you.
Thank you so much, Angie, also for that plug. And you know, she's being modest, of course, as she always is, because we couldn't have put all of the resources together without her and without oversight from Angus and what he's doing as well. One of the things that we really wanted to do with open source and some of these other licenses that Angie's referring to is make non-commercial licensing, when that makes sense, as simple and easy as possible. And we even have a self-service license picker on our website, the TDG website, so that if you have something very simple that you're trying to do, you can follow effectively a flow chart to figure out what to use and when to contact us when you're trying to do something sort of more complicated. So with that, as Angie pointed out, you know, if you have questions on this last slide, please do contact us. You can contact any of us at any time. Our contact information is on our websites as well. I wanted to thank you as well for joining us today. I wanted to thank Angus for joining us, in particular, taking time out of his crazy busy schedule. So thank you. I think, Marvi, if you don't mind stopping the recording at that point.